Good morning. Am I muted? Probably.
Love it.
Okay. Rocking out to a little Jimmy Buffett this morning.
Yeah.
Makes my day.
Heck yeah. Then Aerosmith after that.
A little rock and roll once in a while on the Peloton bike.
Oh, it's good
Okay.
stuff.
Kathleen, Ray Monahan shared a story with me, and I'm going to interrupt our normally programmed event for this article because it just rocked my world. So I will share it with you just so you can see I'm not making this stuff up, because this is like, it epitomizes the value that we as real estate will bring to a transaction, right? There's just been so many naysayers, and Zillow is one of them. So wait till you see this. Let's see.
Can't make this stuff up. It's in real time.
Right.
Excuse me.
All right. I might even read the whole damn thing. When executives at Zillow Group, this is from the Wall Street Journal, by the way. When executives at Zillow Group poured over the company's earnings in the spring, they saw a problem. The real estate firm was making too much money. The real estate firm, they're an advertising company, but let's move on. Zillow, which rose to prominence with online listings, had bet its future on an algorithm based on a flipping outfit called Zillow Offers, which would buy houses, make minor renovations, and sell them quickly. The first quarter delivered home sale profits that were more than twice as high as they anticipated, the company said. Zillow expected to make up money primarily from transaction fees and from services such as title insurance, not from making a killing on the flip. The company's algorithm, which was supposed to predict housing prices, didn't seem to understand the market.
Never did.
Zillow was always behind on its target for home purchases. By the summer, it had the opposite problem. The company later acknowledged it was paying too much money for homes and buying too many of them just when prices were starting to slow. This month, Zillow conceded failure, what amounts to one of the sharpest recent American corporate retreats. It said it would close Zillow Offers, which was responsible for the majority of the company's revenue, but none of its profits. Cut about 2,000 jobs, or 25% of its workforce, and wrote down losses of more than $500 million. It's $500 million on the value of its remaining homes. That's called a faux pas. The company's market cap in February was 48 billion. Now it's 16 billion. So it lost 75% of its value. And I'm not sad. I'm not happy about this in any way, but I'm going to be happy about something in a second. Technology has in many ways transformed the hidebound real estate industry, but Zillow ran into some of the limits of technology and a business still informed by emotional attachments, personal tastes, and other intangible factors.
Bingo.
Ding, 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 ding.
Right there. Right there.
No, it gets better. Some current and former employees say the company's missteps made matters worse. Computer-driven analysis has become mainstream in stock and bond markets, but buying and selling single-family homes has proved a trickier proposition. The real estate market varies widely by city, region, and type of property, with a range of aesthetic, social, and other factors playing into America's home buying decisions. Ding, 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 ding. It's better. Zillow overstretched its staff as it tried to catch up to competitors and disregarded internal concerns that it was overpaying for homes, according to former and current employees. It operated in an unpredictable housing market, with the pandemic fallout helping to spark the biggest housing boom in the generation. And Zillow suffered from supply chain and other labor issues that slowed its ability to renovate homes quickly. That was the breaking point for the business that executives once predicted would generate $20 billion in annual revenue. All right, I'll send this so you can read the rest, but there's one particular part I should have highlighted it.
It's a people business, guys. You can't make a computer do it for you. We have value.
So anyway, I just wanted to share that because
I love this.
Have we been saying, you can't, damn it, go look at the house.
Yeah, I'll be snarky. Mr. Zillow doesn't have a clue what the house looks like inside or out. Hasn't been to the house. Doesn't know about the house. Algorithms don't work. Not when they just don't. Not in this business. And a lot of other businesses, they don't.
One of the quotes said, Zillow was good at predicting 3 bedrooms, but it couldn't figure out if they were in a well-placed layout or not.
I'm sorry, I'm going to gloat in this.
Floor
I'm gonna
plan
be the
matters.
snarky
Floor
one.
plan matters. So guys, just take it to heart. You bring value to a transaction, right? When you're good. And we're going to talk about those
Absolutely.
things.
This big dog figured it out. They rose and fall very quickly. And they had to have a come to Jesus, and my little violin's playing for them.
Yeah. Real estate is a people business, 100% correct.
Thank you,
Okay.
Donna. Right on.
So Kathleen, a little bragging on you. You just passed the Massachusetts bar.
It was a little mini bar. We got through it. I had a stack of law to get in my head in about 3 weeks. We did it. Yay.
And as a result of that, you also got a broker's license in Massachusetts.
Yep, that's coming. And that means more business for my Sarasota and Longboat Key peeps. Boop, boop, boop. That's why I did it.
So what does that mean? So now you're gonna be a broker associate with the broker up there.
Actually, I just have my own brokerage up there, online presence. So everything that comes from Massachusetts comes down here. And, this is just another way of doing growth. When we do our personal aims, we like to look at what we're going to be doing in 5 years. We like to see where we're going to grow. And I did this personal aim 5 years ago, and I hit my target. So these things work, and vision boards too. We can talk about that another time.
Yep. Manifesting our
That's it.
intentions. Manifesting our intentions. Okay. So I've asked you to join me with this because I've counted. I got 8 different lawsuits I'm playing with right now. So let's just talk about, and I'm not trying to scare anybody, please. That's not my mission here.
No.
I don't.
No, not at all.
Because, we're 50,000 transaction-ish in the 30 years I've been doing this, and never once have we gone to court. Okay. But it's earth shattering. It's annoying. It's a gut wrenching when you get into these things, because there's a bunch of low conscious people out there that don't take personal responsibility for their action, and they become victims, and they got to blame. When you're a victim, you have to blame somebody for something that went wrong.
Right.
And unfortunately, that's what a lot of people do when they go to, and there are people that have been screwed too, that deserve to be sued, right? But I don't think we're one of those people. And I know our agents aren't that type of person. So
No.
let's see. I'm going to paraphrase these things, but let's go through the process. So generally speaking, we don't have problems because the contract is set up so we don't have it, right? We write a contract. We negotiate fair terms. We have sellers sign disclosures. We have buyers read the disclosures and sign the disclosures. Then we have professional inspections, check out the stuff. Then we either do repairs or we at least disclose what needs to be done. And then we do a walkthrough inspection prior to closing, make sure everything's right. And then we close and we're happy about our ways, and people live in their houses, go about their lives. It's a pretty simple process until you stop following the process.
Right.
So here's one. It's a $475,000 house in Rusky. Okay. Excuse me. Multiple offers. A buyer from St. Pete sent in a sight unseen offer, as is contract, below asking price.
Okay.
But it turned out to be the most acceptable offer to the seller. Now, this is not a problem, but it's allegedly a problem. In the write-up about the listing, it said you can enjoy the sunset from your hot tub view. Okay. And it is. If you had a hot tub, you could sit in it and watch the sunset.
Sure.
There was a hot tub at the house. Okay. But it was a hot tub that sits on a deck with the plugs into the wall.
So it's movable. It's not affixed to the property.
It's not a
personal
fixture.
property.
Right.
Okay.
It's personal property.
Mhm.
But the article, the write-up said, enjoy the sunset view from your hot tub.
Okay.
Okay. But nowhere in the MLS did it say a hot tub was included. And nowhere in the purchase and sale contract did it say a hot tub was included.
Anywhere in the contract that it said it was excluded?
It was not excluded nor included.
Okay.
But remember, we always say there's 3 contracts, right?
Mm-hmm.
Listing agreement between the seller and the broker.
Right.
Did the listing agreement say the hot tub goes? No. There's the purchase and sale contract between the buyer and the seller. Does that say it goes? No. There's a MLS agreement between the brokers. Now, in the MLS, the write-up did say, enjoy it from your hot tub. Okay, so there's a little bit of possibly fault there.
A little ambiguity.
But I think it falls on the buyer's agent to say, hey, what's going on with that hot tub? But guess what? The buyer's agent never showed the house because the buyers never saw the house.
Okay.
And nobody ever walked through the house before closing to see what was there and what wasn't there.
Okay, all right,
All right.
okay.
So the buyers close and they move into the house. And 3 months later, we get a demand letter for $60,000. So the demand letter is the first shot, which says what?
We're suing you for breach of contract and we,
Well, it
because
says, write us a check or we're going to force you to go to arbitration.
right, yeah,
Because you got to go to arbitration on the FAR bar contract because they
right.
don't want to go straight to court. And the parties refuse to arbitrate.
The buyer's agent is the negligent one here. I'm sorry.
Mhm.
That's my take on it.
So
Doesn't even go to
they
the
asked us to
walkthrough?
arbitrate. They asked us to arbitrate. We said no because
No.
it's a stupid case.
Yeah.
Oh, I'm sorry. The second part of this was it's a 3-bedroom home, but they looked at the tax records after closing
Mhm.
and the tax record says it's a 2-bedroom home.
Okay,
So they figure it's worth $50,000 less now because it's only a 2-bedroom home. But if you physically walk through the house, there's 3 bedrooms. 1 bedroom does not have a closet.
does it
Is
have
a
a window?
closet required to be a bedroom?
You can have a closet, you can have a closet or a window or a pass-through access to the property, to the room from one room to the next with a door.
You know, all you need is a door and a
Right.
window.
Yeah,
A window window that's at least 5.7 square feet that a fireman could crawl through, save you, and pull your ass out if your house caught on fire. Right? That's what a bedroom's required. I checked that with the local contractor. So they're saying $50,000 of the $60,000 claim was the lack of a bedroom, which doesn't matter, which is not true. And the hot tub was missing, which was never included.
personal property.
And then
Buyer's
something
agent
else
is amazing.
happened between, oh, the mailbox was missing. Seller did not take the mailbox.
Seriously?
Somebody stole the
Mailbox
mailbox.
too?
Yeah.
Really?
Which, yeah, well, I'm not kidding. That's what's in their claim.
Maybe somebody took mailbox after they closed. Give me a break.
Mhm.
Come on. Was a mailbox featured in the photos and all that? Here's one thing we got to be careful with. If there's something like that down the road in the future, just put in there doesn't convey. Make sure it's in the contract, doesn't convey. Because some of these buyers agents are just nitpicking the living hell out of
Well,
us.
that's why I'm bringing this up to all of us online
Yeah.
right now, because there are
Yeah.
things we can do to avoid these.
That could be interpreted easily by a court as a personal property that doesn't convey. And unless it
By
was.
definition in real estate, it's personal property. It's not
Yeah.
affixed to the house.
Yeah, it's
And we're getting
not.
questions like, were there pictures of the hot tub? Probably.
Here's the key item here. The fact that you can unplug it and take it, and there's not plumbing extending from the wall into the hot tub, there's your clear cut, hey, this is not a fixture.
Right.
You know,
A good agenting would say, hey, this hot tub is questionable. Let's ask for it. Or a good listing, I don't want to say that because our listing agent didn't do anything wrong. A listing agent could point out the fact to avoid the problem. Hey, take the hot tub away now. Let's avoid the problem. I'll never
Yeah.
forget, Bill Richards, a good customer of mine many, many years ago. What did he do? Oh, he went to Europe and he with his wife and he came back and they bought 2 Tiffany chandeliers. One was $25,000 and one was $15,000. And they put one in the foyer and one in the dining room. Right? I said, take those damn things down, go to Home Depot and get something else.
right,
Because we don't want anybody thinking they're getting those fixtures, right?
right,
and that's
right,
part of
right,
the-
right.
Prior proper care leads to something about those statements I've got. Prior proper planning yields positive results.
Right.
So just the lesson here, and so they wrote a demand letter, we refused to arbitrate, then they hit us with a lawsuit. So what do I have to do? I have to report all claims to the E&O carrier,
That's right.
who sends a claims adjuster out and he reviews the case. And he, in our case, said, this is bullshit. And he denied coverage.
Yeah.
So now that goes back. Now the lawyer's going to, after they deny coverage, then they hit us with a lawsuit.
Okay.
And then the adjuster assigns a lawyer. So I got a lawyer named Jim Hickman, who now has to do this case. So he's got to interview me. He's got to interview the other agent. He's got to do depositions with the buyers. He's got to do depositions with the sellers.
Right.
I got to write a check for $5,000 up front,
Right.
which is not deductible, which is going to be drawn down on his fees. And once we
Right.
exceed 5,000, which we will, the insurance company will pay the rest. And then why would the attorneys do this? Oh, and they didn't claim the buyer's agent had any fault in this, which is really a problem because it tells me they're just out for money from my insurance company.
Yeah. Yeah, and buyers, I'm gonna say it, buyers will say whatever they want the facts to be spun to their attorneys or to anyone else. Because that's their forte. They're only gonna tell people what they want them to know. So when attorneys make representations, rather than say, you're this, you're that, and you're obvious this or obvious that, what they should be saying is, as per my client. That's the way we were taught. I went to a good law school and that's how we were taught. But we're getting people out of these factory law schools. And I'm just going to put it out there. These factory law schools that anybody can get into with a crappy LSAT, and they're coming out and they're hammering out crap like this.
Yep.
I'm sorry, I'm going to be a little bit of a snob, but it's the damn truth. So that's what we're having to deal with. That's why you're seeing an increase on that. And the other thing is, the busier you get, the more likely something down the road is going to come up. Somebody's going to be unhappy, and they're going, what are they looking for? The pockets.
And we have big pockets because we have $1 million policy.
Right. And they know
Now,
that.
here's the rock part of it. What do you think it's going to cost in legal fees on both sides of this? Let's say they keep this act up and they want to go to trial. The insurance company, I paid my $5,000. It's going to be another 30 grand, 40 grand in fees.
Easily.
So what's likely to happen is the insurance company is going to say, screw it. Let's just give them 25 grand and tell them to go away.
That's why people settle. Yeah. I think this will get to the motion for summary judgment. I think if we're able to prove that there's not an existing unresolved material question of fact, then we can get the motion for summary judgment granted. And then we can even possibly go after frivolous if we can show that there was not a good faith here. Those are harder to prove than they look like on paper. But if
I've never had a motion of summary judgment approved, but this one is probably the best case to get one approved.
Yeah, I agree. Yeah, because here the reason why courts don't like to grant them is because your right to jury trial goes right out the window with the motion for summary judgment. And a lot of attorneys forget to explain that to their clients. So that's why we try to get them. It's a great tool. We use it like crazy here in Florida. But this one, I think, is ripe for that.
It makes no sense to me. But once again, the purpose is, what can we learn from this?
Be careful.
Be careful with your wording. Don't mention things there.
Yeah.
Or if you want to be descriptive and talk about the hot tub will go to the sunset, that's great. But make sure the contract says hot tub does not convey.
Yeah. Or
even though it doesn't convey.
Yeah. Or how about just the view from your lanai? I would skip the hot tub altogether. What surprises me about this one is most people hate hot tubs. They don't want somebody else's old plastic thing that's been out there who knows how long. It doesn't add any value. So it really just stuns the heck out of me that somebody.
It's hard to move.
They're awful to move. Nobody wants them.
So the goal here is to remove ambiguity. I am shocked that this came to this stage. That there's actually a lawsuit filed.
Me too.
And I was in meetings yesterday and the attorney called me and said, she actually, I hate this, emailed me to see if I'm available to talk. Just call me, because I could have talked to you in the car, right? But I didn't check my email all the time in the car. But anyway.
But you just brought up something that's important. The reason why she's emailing it, guess what she does with her emails? Just like what we should do with ours.
She bills me.
And it's a record, and she puts it in her little dot loop or her DocuSign files or whatever she uses, just like we should be doing with all our correspondence, with our emails that are very important to our transactions. Save them as a PDF, pop them in your dot loop. That's what she's doing every time she sends you an email. I can assure you, and she's got it on. Instead of what we have a wonderful cloud backup. She uses one of these things, a drive. Right. That's why she's doing that.
Yeah. So what happens is when the case goes back to the insurance company, they say, oh shit, we got to deal with this. They appoint it to a lawyer. Then they send me a letter of explanation, tell me what's going to happen. Then the lawyer sends an introductory letter saying, please send me all of your contract paperwork and all of your email correspondence. Exactly. Okay, that's a big one. So think about this, guys. What if you had to find all of your email correspondence on a transaction? How would you do it?
Pop it in the loop.
Pop it in the loop would be great. But in addition to that, think about your subject line for a minute.
Oh, yes.
123 any street. And then something about it. 123 any street. Or 123 or something. Right. So when you search your Gmail, you can search for 123. And now the agents are doing all this correspondence, not me. And they have to go through all their emails, find every email on this property. And then we have to upload them to the lawyer's server.
Right.
There's a share link she provided. Think of the time involved in this.
It's a lot.
Right. upload every email to the server. Then the attorney's got to read every email and see what is privileged and what is not, because we don't have to share privileged emails.
Right.
But think of the time. I'm doing this on another case right now. And my lawyer, we had 560 emails we were able to find. The law firm gave me their tech person who taught me a new thing in Gmail. And we were able to create a new folder and then because I put 5606 or whatever the number was in every email. So I found all those. And then they had to read all those. And 560 emails.
Yeah.
The bill is $10,000.
You're right. You know, there's something else on this subject that's really, really important. And I think it should be included in every single loop. I've always done it. It's a CYA thing, and I haven't had anything come back to bite me. Praise God, knock on wood. My head is wood. On your walkthrough inspections, we have a form. Buyers pre-closing walkthrough inspection. Buyers accept property in the condition as it is. There's no remaining contingencies, blah, blah, blah. That's a powerful piece of paper to have when you get hit with a lawsuit at the end of the day, to produce to that attorney that you can show, hey, look, there was a walkthrough done. Buyers, everything's fine. Everything's happy. They saw everything they needed to see. We're done here. That's just one more layer of showing you did your what? Your due diligence, and you were a professional.
Well, Kat, what happens when they call to set up the walkthrough inspection and they never do it?
They waived it.
Then what do?
You document your file that they waived it or they refused it.
So in the emails we sent back and forth, we have emails clearly saying, and this is where text messages are hard, because you delete a text, it's gone.
Don't text, please, God.
Don't text people, please. Email.
I'll go off.
Because I want to reference. If we were texting back and forth, I can't make it. Well, that would be a big thing to have on record.
Now, there is a way you can forward those into a email, Gmail account, but now you've disrupted the chain from the actual message to the email and it's broken. You're gonna have a hard time getting that in because they're gonna say you manipulated that message. This is why I don't, and you don't have any privileges attached to your text messages. This is why I can't stand texting. Everybody over here knows, please God, don't text her, only to say hi, bye, and where I'm at, but not about a contract. You know, he's right. I bet you somebody did take the doggone mailbox. It probably wasn't the seller. It was probably somebody that drove by and said, oh, that's a cute mailbox. It's got a fish on it. I like it. And there's nobody living there yet.
How about a screenshot? Screenshot of emails added to .loop. Yes, you don't screenshot them, you PDF them. So you go file, print, choose your printer, Microsoft print to PDF or Apple print to PDF. And
or
then
save to
print
PDF.
Or save to PDF, whatever it's called. And then do that. It'll turn it into a PDF and then just drag the PDF into the loop.
It's
Entitle
so
it
easy.
Email correspondence.
You remember the old days when we had to turn in our bundles,
File.
scan them, and then we had to print our emails, scan them. We're so lucky we have all this technology that makes it so easy. No reason not to use it.
What's it? A pound of prevention's worth an ounce of prevention's worth a pound of cure.
No kidding. Yeah.
I mean, this is just annoying, and the amount of time it takes
It
for me
is.
and the agents sucks.
It is.
And this is frivolous in my case. I think we're gonna get a motion to summary judgment, which says you shouldn't have filed this case in the first place. And
Yeah.
then 2, we should file a motion for frivolous lawsuit.
Yeah, and then ask for the attorney's fees and your actual complaint when you get ready to do that motion summary judgment. That way you'll be able to recapture it. I sent you an article this morning that summarized a lot of those different nuances. It's really important for the attorneys to make sure they have all that pled in to their complaints, and they do. Most of them do. Every now and then they miss it, but we like to get paid. So
Okay, here's another one, and this is a really simple one, but I want everybody to learn that this shit's happening out there, and it affects you and me and everybody else.
Yeah.
This one's just silly. We had it happened to be a Zillow buyer. Zillow buyer called on a mobile home in Brandon. We wrote an offer on the mobile home in Brandon. Of course, the mobile home was owned by a real estate agent who happened to be the broker for a real estate company. They accepted the offer. The offer included a $5,000 deposit to be made within 3 days. It wasn't made. Now, it's not our obligation to remind the buyer to do that, but it's our duty, I would say. Not required, but it should be done, right? And what tool do we have in place for that?
Yeah, we have our escrow receipts, and when we have every opportunity.
Critical date timeline is a reminder, right?
Oh, usually
So
the case. Yeah.
This buyer did not make their deposit. their buyer decided they would find another house they liked. And they called the same agent, said, write an offer on this one too. So we did. And they put the deposit on that one. Well, now the seller found out they're not going to close, and he's pissed, and he's a broker, and he wants the $5,000 deposit. Well, there's no $5,000 deposit. So he writes a scathingly mean letter to me and our agent saying, get me my friggin' deposit or I'm taking you to the real estate commission. To which that was a pretty threatening letter. And then his lawyer wrote another letter and said, I'll give you 7 days to make it right, or we are taking you to FRAC. And now the buyer's deciding, they settled yesterday for $2,500 because it's not worth fighting in court to try to get $5,000 because it costs you 10 to do it. Right. So what went wrong there?
Well,
The responsibility, it wasn't a responsibility of the agent, but it's good agenting to remind the consumer to follow their rights and obligations. You have an obligation to make this deposit. You should have tendered a cancellation when they wrote the other offer.
Right.
This is not Mickey
What
Mouse
happened here?
stuff
How
here.
did that happen?
You get caught up in the moment.
Use your PAs, guys, because they're so good about helping you with this stuff. Please, God.
Yeah,
And
you
use
should
the
be writing
people they
multiple
find.
offers with the same buyer if they're only planning on buying one house.
Make
You
sure-
are, that's fine, but cancel the other one within your cancellation limits.
Yeah, exactly. Man, you could lose your license over this stuff.
Yeah, if that had went to FRAC, there'd be definitely.
We would have
administrative-
lost. Yeah, I'm sorry.
He would have
This
been, the person would have been reprimanded for sure.
If it's a newer agent, first offense, it just depends on your record too. Now, if you've got a record of doing shady things, you can lose your license.
Yeah. So that's number 2 that we're dealing with. That one got solved last night with they split the deposit. Vicky said seller is an agent and a
Good
broker and
point.
did not check to see if the deposit was made.
That blows my mind.
Note to self. You're the listing agent. You need to check to make sure that deposit's in. And the buyer should tell you that it's in. The buyer's agent should tell you it's been tendered. If they don't, you call and check. The title company should tell you that it's there.
Exactly.
Ding, ding, ding. Critical date timeline. If you don't have it, go get
Thank
it.
you. Use it or lose it.
This is going to be an ethics complaint, not ethics, it'll be a board complaint. We sold a house for $880,000. It was a to-be-built home under construction. The house closed for $1,050,000.
Hmm.
The seller only paid commission on $880,000. But nowhere in the MLS did it say commission we paid on final sales price. And a lot of builders don't pay commission on options and upgrades.
No, they don't.
So Remax, the lovely Remax has been hunting our agents. The broker is really a capital B. She decided she wants the commission on the $1,050,000. And she has no claim to it whatsoever. But now there's lawyers involved and they're going to the board. And I talked to the board about it. They said, this is ridiculous. But this broker is now holding that commission up. I paid our agent just because I'm a nice guy. But the title company is holding the balance of the commission. They're holding the whole $880,000, the commission on the 880 price, pending somebody telling them that they're due 3% of the $1,050,000.
You need to get attorney's fees recapped on that one.
Yeah, I don't even have an attorney on this one. This is going straight to the board.
That's such crap.
It's just stupid. But what she's
That
done,
makes me mad. That really makes me mad.
so her agent's commission is sitting there in escrow.
Damaging.
And it's going to sit there because I talked to the board. It's going to sit there for 6 or 8 months before this case is heard. I'd be pissed if I were the agent. Just saying. But I did pay our agent. So it's just going to sit there in escrow. So that's number 3. And the amount of emails went back and forth and scathing phone calls and all this bullshit. It's ridiculous. The
That
amount of
agent should
time.
go after that broker for negligence and for the financial hardship that broker has knowingly and willingly committed. I'd even go so far to spin it as an intentional and a negligent because there's a fiduciary relationship between that broker and that agent as far as getting paid. Okay.
Yeah.
I would twist it that way. I would absolutely go after him or her for that. That's a large amount of money she's sitting on or he's sitting on, knowingly that this is some.
Yeah, it's $25,000, of which like 20,000 belongs to the agent. I'd want
Does
it.
this person not understand that particular type of contract, especially if it's new home construction? Give me a break.
The 4th one, without getting into the date I already talked about, but they required all this email and I had to get the law firm's tech firm to teach me how to do all this stuff. And 560, I paid $10,000 because this one's not going through, to the lawyer to read all my emails. That's just a waste of time. Ridiculous.
And you still have hair. I'm impressed. Yeah, not as long as mine. Ha ha.
Okay, this one is just still out there pending depositions, because now this is where it gets shitty. So what are depositions, Kat?
Well, depositions are an opportunity for lawyers to do what we like to sometimes call a fishing expedition, but in the right sense of the word, is to get additional information and facts to find out where their case is going to head, if they think it's strong enough to go to a trial, or if they think they need to call it a day and just walk away. It's a fact-finding, gathering, evidentiary compilation of sorts. And you've got to be so careful in depots, please, please, please.
And it's intimidating as all get out. You don't want to go there.
And you're sworn. There's you're going to have a court reporter there. They're going to be taking down everything you say. So
but you're paying for, by the way, you're paying for the court reporter.
Oh yeah. Yeah.
You're paying your attorney.
Yeah.
To sit with you. And it takes hours, hours upon hours. And they ask you the stupidest questions and they make you feel like an idiot because they're a quiz. What's it called? What kind of lawyer is the person that does that? They're trained to
interrogations.
Interrogations.
And they're also it's direct cross-examination during trial, and they're preparing the parties for trial. And the other thing that they're looking for is how you react to questions, how you're going to react under pressure. And
it's all NLP, and if you're nervous and if you're shaky, and it's very intimidating. You don't want to go there.
Really important stuff. This is not the time to get creative. This is not the time to embellish. This is not the time to name call. And this is certainly not the time to add things into whatever the question's being asked. Please, 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 please do not add anything. Only answer the question that's being asked. If you don't know, you don't know. You don't have any obligation to.
If you can answer yes, answer yes. Don't say yes because and give a whole bunch of stuff.
Yeah, because if you do a crappy job in the deposition, they're going to say, "Oh, this guy's a hothead. Let's file it and see what happens. We're going to get more money of them because this girl or this guy can't keep their cool about them." So yeah. And talking about depositions, let me back up a minute. These emails that we get back and forth from our co-brokes and so forth, I have found over the years so often co-brokes that are not well trained tend to like to send information from whatever their buyer said to them, completely breaking any kind of confidentiality. They're clueless. And there's been countless times I've had to literally delete and then send a message to the other agent. By the way, you shouldn't be forwarding your client's correspondence talking about all the things that he hates about he or she, or the things he's going to do to the property, because at this point you've put me on notice and now I have to tell my seller, when I'm representing the sellers, which is most of the time, what your buyers' intentions really are in these situations. And then they just purple in the face. Or when you're getting proof of funds, this is another one of my favorites. Rather than getting proof of funds,
keep talking for 30 seconds. I'll be right back.
Okay. Rather than get proof of funds that have a massive amount of money on them, you should always make sure your proof of funds are catered in a way that just reflects that transaction that you're dealing with. I've gotten time after time after time when I've had a deal, let's say it's for $1.5 million, and I'll get proof of funds from that other agent that shows they have $30 million. Now, what have we just done when you do that? You've given me free discovery, which is why I'm bringing it up. Free discovery in the event that this thing goes south. I know you got a ton of money and I can just go right after you for whatever breach that's happened. So you got to be real careful. And I would say the same thing on lender letters. Make sure your lender letters, if you're buying a house that's $500,000 and it shows you can go up to $1 million, don't do that, because the listing agent is going to get stars in their eyes. Now, most of you already know that stuff, but some of you that are brand new may not know that and haven't had this happen to you yet. So you want, when it comes to the money and proof of funds and your pre-approval letters, you want to be real careful with that. I also like to redact out bank account numbers. All we need to know is that there's the name of the person that's providing the funds for our transactions. Another better practice really is to get that letter proof of funds directly from the bank when you're representing the buyer, instead of going on the internet with all their millions and millions of dollars on there. And what are we buying? A guard check worth $1.50. For us as listing agents, when we get free discovery, hey, that's great. But as a buyer's agent, you shouldn't be doing that.
Yep, John, good point. May need to go a little bit higher on the proof of funds. Just don't, if you only need $1 million, don't say you got 10.
Right. Yeah.
You brought up another point we need to talk about. When I represent the seller, I just found this out when we did code of ethics training a few weeks ago. You are required by the code of ethics to disclose your agency to the other party.
Yeah.
So when you have a listing agreement with Century, I don't mean to be pointing at you, I'm just pointing at my pencil.
No, it's fine. It didn't hit me.
Not you. I'm thinking about the audience watching. If you're using our listing package, you are a single agent for the seller,
Right.
and you automatically have consent to transaction,
Consent to
transition to
brokers.
transaction brokers,
Yeah.
right? So when you talk to your first meeting with the buyer's agent, by the way, I represent the seller as a single agent.
Always.
How do you prove you did that?
Copy of it.
Email them a copy of your single agent notice.
Mhm.
I'm sorry, this is the rule. If you're going to play the single agent game,
Yeah.
you got to play it right. And I didn't realize this. So confessions from me, right?
And
But
the
you got to
reason
do
why-
that. You
Yeah,
got to
the
tell them who
reason
you
why-
represent. Because if you're not, if you're a transaction broker, you can't put one party's interest to the detriment of another.
Right. And
As a
it's
single agent, you have
presumption.
to.
Right. Sorry, I didn't mean to interject like that. I ever ready, buddy. I had a lot of coffee today. It's presumed your transactional, right? Unless otherwise what?
Which
Notified.
means you keep your
Notice.
mouth shut. You can collaborate with the other side because you can't put one party's interest to the detriment of another. As a single agent, you're expected to put one party's interest. So you got to put them on notice,
Right.
right? And if you meet the seller or the buyer for some reason, by the way, just so you know, I represent the seller.
Right.
Don't tell me things you don't want me to know. You don't want the seller to know.
Exactly.
So if you have a single agent notice signed with a buyer, you need to tell the listing agent that you are a single agent. How do you do that?
That's right.
So scan your single agent notice, put it in your loop, have it available for download or attach as an email and send it from .loop to whoever you're dealing with
Right.
by email. Don't
Yes.
text them and say, by the way, I'm a single agent. Okay, so that's the deposition one that's going on now. So this has gone through all this other crap we've been through. Now we're waiting to schedule depositions. And everybody has to be there. It's a big thing. You got to drive down. Sometimes we do it by Zoom now, but it's horrible. It's being interrogated, and they're trying to trick you into saying things
That's
that will
right.
give them more things to use against you. It's terrible.
Yeah. Yeah. I hate depots. I did a ton of them over the years. I just absolutely hate them. We only do them on cases that we really think are going to go one way or the other. Sometimes we don't do depots at all because we're afraid of what our witnesses might say. We'll just pass on it altogether and go straight to trial because we don't trust our own witnesses.
No.
I'll tell you we've done that over the years. A lot of us have as lawyers.
All right, number 6. This one is over in Manatee County. And this one, it looks like the seller was fraudulent, and we represented the seller. They signed a seller's disclosure statement saying they didn't know of any work that was done without permits. And the buyers moved into the house, and there's all kinds of water damage that happened during a storm. And the water damage got explored, and they found that there were additions made that were done without permits and all kinds of other stuff. And we checked this disclosure statement. The seller clearly checked no. They don't know of anything. But the sellers owned the home for 27 years, and this work was all done during their ownership. It appears that's the case, right? So we get a demand letter asking us, our listing agent got a demand letter for $25,000. Not the brokerage, not Century 21 Beggins, not Craig Beggins' broker, the listing agent, which means he's got a stupid attorney, number one.
Good. I smell blood.
Yeah. So the attorney demands from the listing agent, we send it to the carrier. The carrier wrote a letter of, no, we're not responsible for this. And he did a very good job on the letter. And then we got followed up with a lawsuit. So now there's a lawsuit that's being investigated. It's been assigned to a lawyer. And I don't know where this one's going to go. I assume we're going to be let go because we didn't know. They can't, it's not our
You
job.
don't have knowledge. You don't
We
have
don't have
possession.
knowledge. We asked the seller, and the seller said no in writing and a disclosure statement. And we're not deemed to have the knowledge to determine
No,
whether it is a permit rebuild job or not.
no. And we don't have possession of any of those records. That's the other part of the equations that's key. And here's another thing. The seller might have had work done, but doesn't know what the builders did or didn't do, and doesn't know what the permits were or were not pulled. A lot of owners have work done and they have no idea that the people that they've hired didn't bother to do the proper protocols. All they know is they hired somebody to do some work way back when, but they don't remember when. That happens a lot.
That's a good point. So that's why there's lawyers.
Right.
Because now the seller's lawyer is going to say, hey, wait a minute, they hired contractors to do this work. We assume the contractors did what they were supposed to. Now they're going to bring the contractor in to the lawsuit
That's who they should be going after.
Mhm. If that's the case.
Yeah, yeah.
Wait, micro buyer with single agency agreement, does the buyer have to sign the handshake agreement is meaningless, has nothing to do with anything other than a prop for you to have the discussion. Please don't cheat on me. It has
Right.
no legal validation or teeth or anything. Single agency is a single agent notice that says single agent notice. I represent you, and it's
Yeah.
signed by the parties.
Yeah, that's what I use. Yeah.
Bubba contractor. Yeah, well, there's a lot of Bubba contractors out there.
Well, there's a ton of bad contractors out there. I can't tell you. I mean, I had a property that came up. I had a roof replaced on it. That contractor had told me it pulled permits and so forth, but I was so busy. This is many, many years ago, unrelated to us. And then I go get ready to sell it. I can't find the roof permits, can't find anything, but I had paperwork showing the roof was done. That's all I had. Sometimes that's all sellers get. I mean, that was back when I was in college before I got my real estate license, which kind of prompted me to go get one after that.
All right, number 7. This is a weird one, and I don't know where this one's going to go. It was a fancy house. It was a Mark Ruttenberg home. If you guys remember Mark Ruttenberg, he's like a mad scientist. The guy's brilliant, builds these beautiful houses.
King of
And they're
Tampa.
like very, very fancy. And this house had one of these really fancy air conditioning systems that did, every room had its own thermostat so you can control it. It was very, very high tech. Well, apparently, the sellers have been having problems with this AC for a while. The house is only like a year and a half old, and the AC has been having problems. And how did they find that out? Because the buyers moved in and the AC wasn't cooling properly. And they met the neighbors who said, yeah, there's been AC people at that house all the time. And they knew the name of the company was there and all that type of stuff. And then people called the AC company who was doing all this work, and they said, yeah, we won't even work on those systems anymore. They're pieces of junk. So now these buyers are really pissed. They bought this $1.5 million house with an AC system, and the seller pretty much didn't disclose the AC problems. And it's an expensive AC.
But I bet there was some kind of warranty in place, I would hope, or some kind of home warranty where they could transfer.
This AC company was doing all the work under warranty.
Okay. Did the seller disclose the AC
No.
company?
The seller disclosed that one little segment was not working properly and it had been replaced, but none of the other problems. That now the neighborhood has confirmed that this AC company has been there all the time, and the AC company has confirmed that they've been there all the time. So it looks like we have a failure to disclose here. Now, that's not our issue, but we got a letter demanding $50,000. They just went to our listing agent too, demanding $50,000 from our listing agent. I mean, I don't know what school they went to that you can't sue an agent. You got to sue the broker.
No. And Sky raises a really good point. Was there not an inspection done on this property prior to closing?
I think this AC was so complicated, the regular home inspector wouldn't understand it. In which case, you hire an AC contractor, not an inspector, home inspector.
Right. Yeah. Yeah. As a bad.
And actually, no, I'm going from memory now. The AC was working fine all during the showings and the contract period.
Okay.
And then the day of the walkthrough, it was warm in there. And the seller said, oh, it's been warm because we've had the doors open all day because we've been moving in and out. So that's why it'll cool down in time. And the buyer accepted that. And then after closing, it never cooled down again.
Probably the compressor went kaput because of the doors being open with the air running full tilt. That'll kill a compressor.
Oh, yeah.
So this could very well have been a problem that developed after closing, unrelated to the service records. That would be my argument. This thing was running the way it should be.
See how attorneys think, guys? See how attorneys think?
Yeah, it was running as it should be. At the time of closing, there was not a problem. And now that there's an issue with it, and it's
well, at time of closing, there was a problem.
Because
the seller explained it away as if because the doors were open.
Did the seller? If the buyers were concerned, they should have investigated that further. Call their AC guy or have the seller say, look, this is way too hot in here. Your air conditioner is not working, and we're not going to close unless you get an AC guy out here.
Right. That's what you say. But here's the problem we're having today.
Okay.
We're going to our seller saying, hey, we don't feel comfortable with this. The seller says, fine, don't close. I'll sell it to somebody else tomorrow for more money than you paid.
Right.
So the buyers are being forced to make bad decisions so they don't lose the house because they need a place to live.
Right. Right.
That's stress you guys are all dealing with out there right now. And I hear it from you all the time.
Yeah. The other side's going to construe that as duress and that they didn't have it. They were going to be homeless. And that's how they're going to spin it. Mm-hmm. Our side's going to say, wait a minute. It's in working order. If they really wanted to go further with this, they could have. They had an option. They waived it. And if they signed off on anything, they said that the property was in acceptable condition and during the walkthrough, and that form is in your dot loop, that's just one more layer.
Mhm.
But I would spin this to mean that this is a post-closing problem and that the air conditioning company can come back out and take care of this. There's some kind of existing warranty somewhere that it's been used for a very, very long time. I would have hoped that there would have been a transferred warranty at that closing from
Mhm.
that AC company, and we're done. We'll call it a day.
Yep. Always two sides to a coin.
Always.
And when it gets to that point, let's say it gets through this, we can't make a decision. It goes to a judge or a jury. How do you know the mood of the judge or the jury?
You
Thank
don't.
God I've never been that far.
Yeah, it's not a fun thing to get one of those things called a jury slip. I don't know if everybody could see this. I got one of these recently, pain in the ass, but I was able to get out of it. But they're going to put me back in rotation for April. But here's what happens when these cases do go to pretrial, because before it gets to a jury stage, we're going to have a series of motions. We're going to be going through a lot of stuff, and then we get to pretrial, and then we're going to shave down what the real issues are. A lot
Oh,
of
and by the way,
times,
how long does it take to get there? Because right now the court systems are really backed up.
when it's a
And-
civil case, it's not a landlord tenant, that's not life, love, or death. It's going to be anywhere between a year and 2 years. The courts are so backed up because of COVID. They're doing everything by Zoom. Another issue we're finding is we're short on staff. It's really, really bad. 50% down on staff because they don't want to work the long, crazy hours. They don't want 500 cases a month to handle anymore. And I'm not just making this stuff up because that's what I used to do. I had 500 cases a month. They were all freaking felonies. So I did triage. I had to just get rid of the dumps, the bad stuff, and just focus on what had to go to trial. 10 jury trials every other week. Guys, think about this. The lawyers that are going to be handling this are exhausted. They don't have the big king size help like they used to. That's only on TV. I'm just here to tell you that's only on TV, unless it's Morgan and Morgan. He has a huge staff, and John doesn't even have to get out of bed in the morning.
He doesn't.
So judges are rotated blindly. Now, here's what we're seeing a lot happening. We're seeing judges getting rotated in civil, and they got a criminal background, or judges getting rotated into criminal, and they have a civil background. They are limping along. We've even seen this in some cases that are ongoing right now in national news. I'll keep the name of the case out of it, but I think that judge is an idiot. He's letting in all kinds of stuff, and he's just all over the place. So that's what we're dealing with out there right now. So there's a good chance you can get a judge who doesn't even have a freaking clue. He's scared of the lawyers. That's the politics behind the judiciary, and they're never going to tell you this, but I'll tell you that. They're scared to death of us because we know more than they do. So it's a flip of the coin. I would love to settle something like this if it ends up at a jury trial. I'd rather settle it and make it go away.
And John wrote in, hold in escrow. That's a great idea. How do you do an escrow holdback?
Draw it up.
Number one, it takes agreement. We have another one of these going on right now. This is, so this is number 9. This isn't a lawsuit yet. It's just a complaint.
Yeah, hold back.
The bathroom, there was a soft place in the floor outside of the shower. The home inspector recognized it. The seller had already had it repaired once, didn't disclose it again, but they had a contractor come out to fix it, and the contractor didn't finish it in time for closing. We suggested an escrow holdback. They said, hell no. We're not doing an escrow holdback. The contractor will come fix it after closing. We already paid him. Okay, this is serious. What we should have done is said escrow holdback or extend closing.
Right.
Because what happened was the contractor came back to fix the floor like he said he would. And when he got into it, he said, oh, there's water damage back there. So now it's a $5,000 problem. And guess who's got to pay it? The new buyer.
That's right.
So even if you do an escrow holdback, that's why the contract says you hold back 1.5 times the amount of the estimate. I'd hold back double the estimate. But the sellers literally said, screw you. Don't close. We'll sell it to somebody else. And the buyers needed a place to live, so they took it. Now, in this case, the buyers made $15,000 higher than asking price on their other house. So they have the cash to make the repair, but they're pissed about it. But that's because we weren't strong enough to say, look, too many things can go wrong if you close right now. Just be aware that if there's something comes up, it's your problem, and have that discussion with them. Because if you have the discussion, it goes easier.
It does.
'Cause right now, their emotions are just pissed.
Right.
Right. And we tried to get the escrow hold back, but they said no. And we needed the house.
Yeah.
So just got to tell them the risk is on you if we do this. I recommend you postpone closing. And then you get a lawyer to write a letter explaining this, make it threatening.
Mm-hmm.
put a little Liz Pendens on the property, keep it from selling to somebody else.
Mhm.
There's things you can do, but it takes a lawyer. And I
It
know you
does.
don't like to hear that, but sometimes we got to step up and tell these people what's really going on.
Yeah.
Because this is a lot of crap that I'm going over with you.
We're in the business of making
That
sure
was
we have
9.
the right hat. You know, on that very point, we had a situation like that come up with a roof issue. And I made sure it was in the contract that there was going to be a holdback for replacement of the roof from the escrow funds in the contract. And thankfully, we had a Century 21 agent on the other side, a different brokerage, but still Century 21. So they understand our procedures and so forth. And we hold things a higher standard. We do things a little bit better. We couldn't get insurance, even though the lender said we would be able to, we couldn't. So we ended up, the seller agreed to replace the roof and get it all done before closing, because initially that language is in the contract. Now, I know you're not supposed to put it in the contract. You put it in a separate addendum, but this was strategic to put it in the contract. In the event that there was an issue, we could work and make the seller come to the table and put that roof on, because we knew that we could get that because we got her to agree on the holdback of the funds. It's very tricky lawyering, but it saved us a whole lot of problems. We closed and the buyer has no idea how hard we worked on that. And the agent, I have to give her a shout out. Her name is Sky. And this was her very first deal. And we worked through this all the way up till last week. It was very stressful. She had the most ungrateful buyer on the planet, but we got it closed. And it was just careful lawyering. And I try to keep her calm, let her know we're going to close this. We're going to close this. It's going to close. And we did it up front with the escrow holdback. That's the reason why this thing closed.
Regina wrote in on the Q&A, which I wasn't watching this closely. If you have a home inspection done prior to listing, but the seller feels way too many items to repair and wants to sell completely as is, no repairs, period, what would you suggest? Drop the price by the amount of the repairs times 1.5.
That's right.
Because I'm the buyer. You got to disclose all those problems now.
You're on notice.
I'm going to know about it. And I'm going to figure there's more than that.
Yeah.
So that's what I would tell the seller. Look, either fix it or drop the price by that amount times 1.5.
Yeah.
Making inspection report available or walk away. Initially, once he got the report back, he was upset about having done the home inspection because he felt what he did know he would have had to disclose. They're going to find out anyway, guys. He's
House could
kicking
be
the can
brand
down the
new.
street.
Yeah. You can have a brand new house and there's going to be something. They're paid to find something. So we look to see what are the material issues that you really need to get done.
Yes.
We're not the nitpicky wallpaper. I don't like the color of paint stuff, the serious stuff.
Personal responsibility for your actions. Number one, you should have maintained your house. Call it what it is, right? When something breaks, you fix it, and then it keeps other things from breaking. I'm sorry to be a jerk about it, but you're not a victim here, right?
Right.
So yes, oh, I wish I didn't know, then I wouldn't have to disclose. Well, you're a dishonest person,
Yeah.
right?
Yeah.
You find out, you disclose.
Yeah.
Get estimates for all the work to be done. Do whatever you can with the buyer at ease.
Exactly. Exactly. Well, and the other thing, the best thing about these pre-loved home inspections, you know what it saves you? A headache on the back end. I had purchased a condo over here a couple of years ago. Thought it was in mint shape. Everything was fine. We thought the inspector did a great job. So we get ready to sell it. I have it re-inspected by our people on this side of the uptown. The smoke alarms that are hardwired were not wired properly. We're lucky the place didn't burn down. We didn't know. There was a problem in the breaker, a double tap that we didn't know about. And the stove kept popping a fuse, popping. So because I had that done before I listed, all those things got repaired. Everything was, and I was able to present that to the buyers. And I have a clean conscience. I know I did the right thing. Now I was fighting a spouse on this who, I don't want to do that. And I said, fine, I'm going to pay for it and you're going to reimburse me. How about that? Because I'm not going to play these games, because we got somebody who's got a squeaky elbow, doesn't want to spend $200-300 stinking dollars to make $500,000. I mean, does that make sense to you? Spend the money, write it off.
Woody wrote, would a home warranty have covered this particular AC problem? Let me tell you this. A $700 warranty is not there to solve a $15,000 problem.
No.
Right? So if it's something that they can get out of, they're going to get out of it. Call it what it is.
Right.
Now, with the home warranty addendum, I mean, this is a really complicated AC issue, so I can't really speak to it. But under a normal home warranty, if there was an inspection, it was documented working at the time of the inspection, yes, it would be covered for the repair up to the maximum repair limit, whatever that is in the contract. But don't go telling a buyer, get a home warranty and you get a $15,000 air conditioning system.
Oh, no.
because there's a limit of 2,500 or 5,000, whatever it is, which is a hell of a return on your $700 investment.
True.
But don't go telling them it's going to be replaced, because that
Oh,
may
no.
or may not be true.
No, it may or may not, but it also shows good faith on your end and due diligence that you were trying to protect your buyer for any possible within limits of repairs.
Within limits is a very important statement to make.
It is.
And then back to Regina's guy that is pissed off he has to disclose. He thinks he's Mr. Fix It, but it's crap, not done professionally or correctly. Sometimes, guys, you walk away, right? This is going to be a problem. I've got a crystal ball in front of me. I'm seeing it right now. If I had to predict where a problem is going to be, it's going to be right there. Right?
Yeah.
I'm sorry.
Yeah.
Regina, you banged out 20 deals already this year. But the extra one, I know you want to help people, but they need to take your advice and trust your professionalism. And if they're not willing to do that,
That's it.
I'd say bye. Or control them more. Say, no. If we're going to work together, you're going to do it the right way.
Oh, you'll
Either
get sellers.
get estimates from professionals to fix it properly.
Right.
Now, the one benefit of doing it before closing, before contract, before listing it, is you can do it yourself, but do it right. And if you don't know how to do it right, have somebody help you do it right, or hire somebody to do it right.
My take on.
Or go to YouTube and figure out how to do it right.
Don't do it yourself, because if there's something wired wrong or something that goes kaput, you're going to be on the hook for liability. There's old case law out there. If you replace a step on a step of stairs and the step breaks and you're the landlord that replaced it and repaired it, you're on the hook for that liability. I don't ever recommend my sellers to do their own repairs. I always tell them there's always a chance this will come back to bite you in a lawsuit. The cleanest way to do this, if the buyers want to do it, is to give them a credit at closing and let them go get their repairs done.
And that's scary for the buyer, because the credit for repairs may not be enough to cover it, because they get behind the tile and find out there's water damage. Then you go.
Right. Yeah.
So I just want you guys to be aware, because awareness gives you flexibility, and flexibility gives you options, and options give you power.
Yeah.
So this is a good class, just awareness things. Amy, good advice. She says, I never say something's covered under a home warranty. I have them contact the home warranty company.
You got to read
That's perfect. And that home warranty, someone's got a great customer service center.
Yes, it has limits, and you have to know what the limits are. Contact 1-800, whatever the number is. Sure.
That's it.
It's knowing what hat you wear, and don't let them pigeonhole you into wearing multiple hats. Nothing.
And for God's sake, slow down, right?
Yes.
There's not a race. We're only doing, if you're selling 50 houses a year, which most of you are not, that's one a week.
Yeah.
Right? You got extra time.
Right.
Slow down, think about it, and ask. Ask me, ask Kat, ask Thomas, ask Jeff, ask Otis, ask Joe, ask whoever else I think right now.
And
we're all there to help. Julie.
Please put your deals into .loop from the
Yes,
very
use
beginning.
.loop as your filing cabinet.
Yes.
If you had a filing cabinet, you had this piece of paper and you want to put it in the filing cabinet, you go do it, right? Now you just take a PDF of it and put it in .loop.
Yes, add your
get out of your
managers to the
seat.
team. Yeah, the reason why you add your managers to the team is no, we're not snooping in your email. No, we're not going to be up at midnight reading what you wrote. The reason why we like to be on your team and add it into transactions. So when you have a question in the middle of the night, we click it, we can look at it with you. If you tell me you have a contract and it's I'm
You should be able to log in to as a manager anyway.
Yeah, as a manager,
They don't need to add you to the team. You can just look.
Well, not
your
unless
office.
you're added. Mm-mm.
No?
No, you got to be added in there. Yeah. No.
Angelique, is that true? I thought the managers had access to their office's
If
files.
they ask for it, yes, but if they haven't, no. No.
That is correct.
So it's good to have everything in .loop, so we're able to help you, because there's all types of contracts out there. We're not going to know which one you're dealing with.
I have access to everything.
Yeah,
And I sit up at night and read all your files, let me tell you.
You're the god. We're not worthy. We're not worthy. Sorry, gonna have fun with that.
Joe Jenner says, I put everything in .loop, and that's smart. And then what I want you to do is tell the customer to use .loop going forward past the transaction. When they buy a new refrigerator, scan the receipt and throw it in .loop. Use it as their home filing cabinet.
Think of it as
Right?
it's your file. It's your file, man.
Very cool.
Yeah.
All right, 9:30 on my end. It's Friday. It's the Friday before Thanksgiving week. So now is the test. How many of you are going to work next week? Because the excuse is, well, Thanksgiving's on Thursday. So you're going to take Monday, Tuesday, and Wednesday off? I don't think so. Oh, we'll get some hands going up.
Make money. The best time to make money is from here to the end of the year, because what is everybody else's? I always made a killing in November, December, always.
Well, if you're not making a killing in November, December, you're lining up a killing for January, February, and March.
Right,
You're stocking the pond right now. If you're working and nobody else is, you're getting all the business.
right.
So watch the reload company, watch all the incoming leads. They're going to be bouncing around. I can show you.
Mhm.
They'll go through 40, 50 agents before they get one that'll answer it.
Yeah.
So if you're the one who's answering your phone next month, you're going to be really set for this month and next quarter.
You gotta stay hungry, my friends.
7 new messages. My God, this is interactive today.
Good,
As a landlord, always use a licensed contractor. Yes, Kat talked about
absolutely.
that. No, I'll be out of the country. Well, that's okay. Yeah, you're going on a cruise, dude. You deserve it.
Oh, man, I wish that was me.
I'm working. I'll be working Monday through Wednesday and Friday. Yeah, of course. I'll be working on Thursday because I guarantee you some of you will call me on Thursday. And that's fine.
Maybe they'll send you Thanksgiving Craig in a can like I did a couple years ago.
That's right.
Remember that ugly thing? Craig's Thanksgiving dinner in a can. It was so freaking funny.
It was gross too.
See?
Okay, it is Friday. Happy Friday. Stay safe this weekend.
Yeah.
Be good. If you can't be good, be safe.
You want more classes on this? Let us know, because I love doing this.
Yeah, I'll get some more issues, I'm sure. So we'll have
Yeah.
more to talk about.
Yeah, absolutely.
Oh, lots of thank yous. All right. Thank you, Rena. Thank you, Rachel. All right, pay attention. I don't want to be talking about you on these cases.
Mm.
Thanks, everyone.
Take care. Peace out.